Good morning and welcome to the webinar. This is Roger Royce. I'm the founder of the Royce Law Firm, a business, tax, and corporate law firm with offices in Northern and Southern California. Today we have a presentation by Satya Narayan, an attorney here at Royce Law Firm, who is going to discuss the legal challenges for big data vendors, including issues related to data privacy and security, compliance, and service level guarantees. Satya is going to discuss the potential legal risks and liabilities for data vendors that they need to be aware of regarding these issues, and the operational, contractual, and commercial best practices and the steps that vendors can take to manage these risks and liabilities. Our webinar will go for about 1 hour. Keep in mind that there is a dialog box on your screen. If you have questions, please type your questions into the box and we'll collect them and answer those questions at the end of the webinar if time permits, or follow up with you directly. As usual, this webinar is being recorded. You'll be able to find a replay of this on our site at royceuniversity.com. You will also find it on the Royce Law YouTube site, as well as available for download as a podcast at the iTunes store. So with that, I'm going to turn it over to Satya.
Good morning, everybody, and thanks for that introduction, Roger. So today I'll be focusing on the legal challenges for big data companies, and really more specifically for the providers and vendors who analyze and manage data for enterprise customers. Just as an introductory, big data is a term that describes large volumes of high-velocity, complex, and variable data that requires advanced techniques and technologies to enable the capture, storage, distribution, management, and analysis of the information. That's the definition provided by the Tech American Foundation. I did like this little diagram that they provide, where they actually have volume, velocity, and variety listed. And I added veracity from Microsoft's big data website. So big data is not only about managing just the copious volumes of data, but also how analyzing that data quickly and providing that analysis to your customers. It also involves the variety, just the multiple video feeds, for example, to target points of interest. And at the end of the day, being able to connect these different data points to enable your customers to make decisions. So you see big data everywhere. You see it with e-commerce companies using big data technologies to sort through their clickstream and historical purchase data to provide relevant product offerings to consumers. You see big data technologies helping companies devise cost reduction strategies. You see big data companies helping enterprise customers, complete consumer profiles to improve their consumer relationship and support functions. Some of the key legal concerns that providers and vendors of big data should keep in mind are data privacy and security, compliance issues, service levels that they provide to those enterprise customers, reliability and other warranties, and indemnifications and limitations of liability that they include in their contracts with their customers. So taking that first piece, data privacy. Data privacy goes to personal information, personally identifiable information of users of your customers. So for example, if your customer has a large end-user database, then they're going to have personally identifiable information, which is essentially information that goes to identify an individual or that can be used to identify an individual. The thing as a provider or a vendor supporting your enterprise customers, the things you need to keep in mind are whether your enterprise customer is getting sufficient permissions from their end user base as are necessary for you as a provider to perform the functions on that data set. Some of the unique things that are also need to be kept in mind based on what end user database you're working with, and what kind of big data technology you're providing. Some things, for example, in the financial space, you might be subject to the Fair Credit Reporting Act, in which case, or your enterprise customer may be, in which case consumers have a right to correct their personal information. Whether or not that's doable in the database you are managing for your enterprise customer, that's something to keep in mind. And then there is the do not, this should be do not target versus do not collect debate. There's a typo here. I apologize for that. But there's a do not target versus do not collect debate that's going on right now. The do not target debate is about the advertising industry really saying we can collect information from consumers, but so long as we don't use it to target consumers, then it should be okay under applicable law. But increasingly, the Federal Trade Commission and privacy advocates are want to include in that debate the do not collect scenario, meaning, well, you know, do not collect such information in the first place without the consumer's permission. Then, if you are, as a provider, collecting end user information, or even if you're collecting as a direct, in a direct relationship with the end user, it's really important to keep in mind that you know, even if you think you are anonymizing the data and using the data set in an anonymized fashion or disclosing it back into the public domain, then you have to be really careful that that data cannot be reconstituted so that it becomes personally identifiable to a person. And while it seems like it's this is quite hard given that it's aggregated data, it actually isn't, and as was found in a recent the recent situation with Netflix, where they released the anonymized data set of a large base of their consumers, and two researchers from the University of Texas were able to take that anonymized data, connect some of the Netflix reviews by the consumers who were part of that data set with some publicly available reviews from IMDb and other locations to then be able to identify those consumers. And there was actually, subsequent to that, there was a lawsuit by a consumer filed against Netflix, which was settled eventually. But it really goes to show that it's not, there are a lot of researchers and there are a lot of people out there who can actually aggregate and anonymize data and put it back together to make it personally identifiable. Next slide. Data security. This is obviously another important legal concern for big data providers. And I like to talk about data security also in the context of who the provider's hosting partner is. For example, if Amazon is your hosting partner, Amazon's terms will only provide for reasonable and appropriate security measures. Are those enough when it comes to your enterprise customers? More often than not, you will find that your customers will be asking you for lengthy data security questionnaires to be completed, and they will ask you to sign a broad data privacy schedule or agreement, where you essentially have to take on all of the liability associated with any compromise to the data that you're analyzing or you're storing, or on behalf of your customers. So I think it's really important to understand what security measures your hosting provider is providing, and making sure that you either transmit the same level of measures down to your customers, and you maintain a consistent security policy where you're not over-promising your customers. Now, that can be a difficult task given that a lot of the large enterprise customers are going to ask you to sign up to their data privacy schedules. But no data privacy schedule is is written in stone, is the way I like to look at it, and I've been able to get a lot of big data startup companies in a position to negotiate those data privacy schedules to something that is reasonable. So the other things to keep in mind with the data security are security audits. Now, your enterprise customer is likely going to ask for an audit of the security measures that you take in your general operations if you're going to be holding personally identifiable data and sensitive data for them. Now, again, you can certainly audit your systems, but keep in mind that Amazon is not going to like having their servers audited by all of these by their customers. What Amazon does essentially is they do their own independent audit, and they provide reports based on it, which you can share with your enterprise customers. And there's really a balancing act that you have to do with your enterprise customers because they're going to ask for an audit of all of your contractors. And technically, in such situations, you know, an Amazon or a Rackspace would be considered a contractor, but they would not be willing to essentially sign up to the kind of broad audit clauses that your customers may ask you. So then to what extent, this is an important question as well, to what extent should your customers be responsible for data security and privacy issues? I think we spoke about this just a little briefly in the prior slide when it came to ensuring that your customers obtain sufficient end-user permissions for you to do the analyses and whatever other functions you want to perform on that data set. So to a certain extent, we need to make sure and we need to assign that risk allocation to the customer. If they don't get the necessary permissions and you are essentially doing what your customers ask you to do, then it seems reasonable that the customer should take on any liability associated with not getting the right permission sets. And finally, who bears the risk of a no-fault breach? And this is just pure risk allocation when it comes to a no-fault breach. What is a no-fault breach? So you've taken, as a provider, you've taken all of the security measures that you think are industry standard. You've put in all of the firewalls. You've encrypted all of the data, or most of the sensitive data, and still, you know, your servers, they get hacked, or a virus enters your systems. Now whose fault is it? Data is corrupted. Data is disclosed. Whose fault is it? And this is really always a tough negotiation, and it essentially ends up, you know, depending on who has more bargaining power in the relationship, in the transaction, it ends up on the side with the lesser amount of bargaining strength. But there are ways to manage even that. Usually, I do that through putting a cap, essentially, on all data breaches, and I have been quite successful at getting that cap. In fact, it's really though, how do you present that in the negotiation? What stage? And you know, how do you get the customer to come around to your side to understand, you know, these are the levels of security measures you take, and then at the end of the day, there is going to be a no-fault breach potentially down the road. And if there is, how do you manage that? Okay, next slide. So just wanted to put in a slide here to show you the cost of data security breaches. As you can see on the graphic on the left-hand side of this, there are three lines. The green line is the malicious attack. This is where you may have taken whatever security measures industry standard security measures, and still hackers have breached your firewalls and your systems, and you can see that is quite high. Then there is the orange line, which represents a system glitch, and of course the blue line where it's purely related to negligence. On the right-hand side graphic, you can see how the vulnerabilities have been increasing each year, and the general consensus at this point is that the cost of a data breach is somewhere in the range of $5 to $7 million, and the per record cost of data breach is $214, according to the Ponemon Institute, Symantec. Next slide. So continuing a little bit further on data security. So this slide really goes to talking about what are the potential costs, and can these potential costs of a data security breach be shared. Data security breach costs involve notification-related costs. This is, the notifications you have to send to each user under applicable law. Massachusetts, I think, has the tightest notification-related laws, and you have to notify, all of the users. You have to notify the Federal Trade Commission. You have to notify various state and regulatory authorities. Then other costs of data security, support costs. Now, your customer may ask you, in addition to these notification-related costs, which they incur because they have to comply with notification obligations under law, they may ask you to also cover their out-of-pocket expense of setting up a help desk to take consumer calls related to the data security breach. And then there might be credit monitoring services that you have to provide, that the enterprise customer has to provide, for which they will then turn back to the provider where the breach occurred to essentially make them whole for those costs. Other costs, fines by the SEC, potential litigation costs. These are all the various costs that your enterprise customers will potentially turn around and ask you to indemnify them for. Security audit costs. This is the cost associated with conducting, for example, an SSAE 16 Type 2 audit, which most enterprise customers for whom you provide essentially outsourced or platform-based data analysis services may ask you to conduct. And that audit can be quite expensive. It just depends on what kind of service you're providing, where the servers are located, and how complex and how quickly the audit needs to be completed. But it's anywhere, it starts in the range of $20,000 and it goes upwards. The security audit cost, conducting this SSAE 16 Type 2 audit, this is a cost which I have been able to help startups negotiate with enterprise customers a sharing arrangement, because that's not something that a startup typically contemplates as part of the fees that they charge, the subscription fees that they charge to their clients. Also, usually I find that this type of audit comes up when you are dealing with really large customers, and usually it ends up being a good business discussion where the bigger company says, okay, this is the first time you're doing it, I get it, we can share the cost up to a certain amount. It's a delicate discussion, but it is something that we've managed to have put into a sharing arrangement. Then there are the implementation costs of new security measures. So one of the things that I think a lot of providers of big data technologies, particularly startup and mid-sized companies, fail to realize is that once the audit is completed, there are going to be a lot of, potentially there can be changes that are required to your technology to improve the security measures, changes that are required to your operations. Now, these can be quite costly, and the question really is, do we want to take on those costs? Is it worthwhile, that particular deal with that particular customer? Is it a worthwhile enough deal for us to take on those costs? Or is your customer willing to share those costs with you? Or if it's too costly and your customer is not willing to share it with you, and you're not this is not the right stage for you to implement those measures. Do you want to consider, as a vendor, to step out of that relationship? So one of the things I've been able to negotiate around implementation costs of new security measures or new features you want to put in your technology to achieve that security level is, giving the vendor and giving the parties a choice to either mutually agree to share that cost at that stage when that cost arises, or to, handshake and terminate the relationship with no further liability. Next slide. So moving past data security, and actually data security will come up in a few slides yet, but moving to compliance issues. So it's really important from a provider's perspective to understand what is your role when it comes to data-related compliance. The data privacy and security-related compliance, we've spoken about that in prior slides extensively. Now about e-discovery and document preservation. Now this is an important one because in the United States, often it's compulsory to provide during discovery, e-discovery of in a litigation, to provide electronically stored information that's relevant to the litigation to be viewed by the other side and reviewed. Now, if you are, and it does happen quite often these days, given the global nature of business, if you are a platform which is not only analyzing data sets of end users based in the U.S., but also outside the U.S., in the EU, for example, then there are a number of EU member states that specifically require and in their laws, data privacy laws, that you cannot furnish personally identifiable data records or end user information in e-discovery, so in a litigation-related discovery. And they impose severe sanctions for that. So if you are doing global business and you have a litigation scenario where you have these data sets which are global in their nature and relate to end users in the EU as an example, then you have to work with Privacy Counsel in the U.S. and outside the U.S. to make sure you are complying with data privacy laws when you are providing data sets for e-discovery. Then regulatory compliance. This is really key in specific industries. For example, in the pharma and automotive industries and the banking and financial industry. In the pharma industry, you have HIPAA and you have the High-Tech Act. These are all related to protecting health information of individuals. In the banking and financial industry, you have the Gramm-Leach-Bliley laws, and you have various security standards, including the PCI, the payment card industry security standards that you would need to comply with. So depending on exactly, what is the nature of the personally identifiable information you are processing. If it includes, credit card information, then additional security measures may be required. If you're using, if you're using social security numbers, it's sensitive data and it requires certainly, for example, you would need to use encryption to protect that data. If you are just collecting names and email addresses, you may not need the same level of security measures as more specific to these to these industries which involve highly sensitive data. But again, that is an analysis to be made in discussion with your lawyer and a close understanding of exactly what types of data you're collecting, or what types of data are being provided to you by your enterprise customers, and what type of processing activities you need to take. Next slide. So moving away now from data, I wanted to address service levels. So big data technologies is all about using the next technology, the next software, which can analyze and process that data quickly to produce certain results. Now, and then providing that service potentially in a hosted fashion, which is often the case. So the really important set of obligations and risk allocation that comes into the picture in your contract with your enterprise customers are service levels. You know, what type of performance guarantees should you as a provider give? Should you provide uptime, throughput, mean time to restore, you know, bandwidth guarantees? What type of warranties are your customers asking you for? These are something. These are important enough from a risk allocation perspective, and they can expose you to liability, enough liability that you should make sure that whatever form contracts you develop as your, for example, like your customer agreement that you develop, you do it in close association with a lawyer who understands what risks and liabilities can result from the particular technologies you are using and what guarantees you can provide. As an example, you know, when it comes to uptime, if you are using Amazon as your hosting provider, they only provide a certain amount of uptime, 99.5%, and they limit their liability to the fees paid in a 12-month period. Now, you know, your customer is going to say, well, I may want more than that. I may want, you know, ultimately, I may want all the fees paid under the agreement. Or I don't want just service credits. I want other options. So these are all things that, you know, one has to consider depending on, based on the criticality of your service to your customer's operations and how it affects the customer's, you know, outward-facing business, and to manage those warranties and service levels accordingly. There are limitations and exclusions which, and remedies that we as lawyers can assist and develop for you, which will ensure that you are not providing warranties for, you know, for example, Amazon's hosting failures, or you know, we can help with providing exclusive remedies drafted into your contract, so that your liability is limited to, say, 10% of the fees paid on a monthly basis, based on, you know, you not achieving an uptime of a certain percentage within a certain range, measured over a certain period. So there's several ways and several metrics that go into the analysis of how to limit that liability that is worthwhile having that discussion with your lawyer. And ultimately, also, you know, to what extent do your customers' duties and responsibilities impact on your performance guarantees? Obviously, we don't want to be. I think it's really important that we exclude situations where, you know, the customer's misuse of your service somehow impacts on the performance guarantee. Next slide. So, in addition to service levels, I have seen customers ask for data accuracy and completeness, related warranties. I have seen customers ask for no virus warranties. I've seen customers ask for software performance warranties. You know, all of these software performance, depending on whether I view it as a service or whether I view it as really the performance of software, we may choose not to give such a warranty. If it is truly based on the software, on a proprietary software that performs, you know, the certain specific functions according to, you know, its specifications and documentation, then we may give. It may make sense to provide, you know, a warranty that the software performs substantially in accordance with its documentation. But in other cases where it's really more of a service, where, you know, you are using a lot of third-party technologies and sort of blending all of that to provide reports, as an example, of, you know, consumer behavior, then a software performance warranty may not be an appropriate warranty to provide, you know, for your business. Now, data accuracy and completeness. Now, I almost always say no to a warranty around data accuracy and completeness for big data providers, only because this is all data that's either provided by your customer's end user base, which may or may not be accurate. But also, many times, if you are a big data provider, you're analyzing that data for your enterprise customers. You're analyzing it against potentially data from other data brokers. And the moment you mix all of that up and to provide a response, you are relying on essentially data sets from third parties. So it becomes really dangerous to give any sort of data accuracy or completeness warranty. Keep in mind that apart from any express warranties, these are warranties that your customers expressly require in a contract. There are warranties that are implied by under the law, by a statute. For example, under the Uniform Commercial Code, you have the warranties of merchantability, fitness for a particular purpose, non-infringement of third-party rights. It's really important that you disclaim those implied warranties. And again, just how that disclaimer is drafted is very important to make sure that it's effective. It's not sufficient, for example, to say you disclaim all warranties under implied by law. That's insufficient. So again, this is where we as lawyers can assist with providing text that adequately protects you from any implied warranties. Exclusions, again, I think this is related to something we talked about, the service levels. You want to, as far as possible, exclude anything that causes you to breach your warranty on account of some third party's actions or your customer's actions. Next slide. Indemnifications and limitations of liability. These are essentially the risk allocation provisions which will eventually limit, are designed to try to limit your liability. For example, if you, if there is a security breach and it's because we didn't adequately take the security measures required under the terms of the contract, your customer may ask you for an indemnification for that breach. An indemnification is essentially a promise to pay, upfront, and it's something that has to be carefully considered. You don't want to always provide an indemnification for claims that are made, exclusively by your customer and are not based on some injury being suffered by that customer from third-party claims, from third-party sources. So, for example, if and even then, if, for example, the customer's end-user base sues the customer, do you want to be on the hook to provide coverage for that to your customer? It's not as straightforward an answer if you think that, well, it resulted from your breach of some obligation you undertook under the contract as a provider, and that resulted in a claim from an end user, and therefore we should indemnify our customer. It's not as simple as that. There are a lot of measures that your customers can take in their contracts with end users to disclaim a lot of liabilities. And as far as possible, in an effort to limit your liability, we as your lawyers would recommend, what are the steps we can help you take in your contract with your customers and shift or diminish that, mitigate that liability arising from third-party sources. So I'm going to jump a little bit to the limitations on the provider's liability. If you are working off of the customer's agreement, one of the things that we as lawyers often find is that a disclaimer of consequential damages may be missing. Now that is really important when if you breach an obligation, for example, related to data security, or if your software infringes a third party's IP, or you breach a simple service level obligation and that affects some critical functionality for the customer, which eventually results in damages. You don't want to be on the hook for essentially the customer's lost profits. These are consequential damages that are regularly disclaimed in the industry, and it's something that we as lawyers can identify for you. There are certain types of liabilities, such as confidentiality breaches. which are excluded quite regularly from consequential damages disclaimers. But even then, when it comes to, for example, a data-related breach, one has to be careful. For example, I have agreed often to exclude confidentiality breaches from any limitation of liability, but I often, state very clearly that if it is a confidentiality breach related to a data privacy obligation, meaning with respect to personally identifiable data or customer or end user data, then we cap the liability at some, at several millions of dollars, but we cap that liability because, you may have taken the security measures necessary to protect that data, but it gets hacked anyway. Now you are not only in breach of your data privacy obligations and data security obligations, but you're also in breach of your confidentiality obligations. And so you just want to make sure that for data-related breaches, the liability is controlled. And then caps on liability, again, putting a dollar figure to liability as far as possible. What is industry standard, and what is negotiable? These are things that we as your lawyers can assist you with, knowing and having done these kind of transactions for other big data vendors and other providers. Insurance, really quickly on insurance, whatever liabilities we take on in our contract, it's really important that we get the appropriate insurance from a customer's perspective to back up our obligations, but from the provider's perspective, really so that one bad deal doesn't result in your business tanking. Insurance, you get various types of insurance, but for example, like for data privacy and data security related breaches, you want to get E&O insurance, which addresses data security breaches. You don't get that just in a standard E&O insurance. So again, something to look at closely with your lawyer, and we can advise them. Next slide. So additional customer asks of big data technology providers is post-termination transition and migration assistance. I've seen very broad clauses when it comes to this, and the thing you have to be careful about here is you don't end up providing assistance of such a nature that you will be essentially helping your competitor take on this customer and learning what your technology does. So you got to be really careful, because whenever transition or migration assistance is involved, if it's not a migration to the client's in-house technologies, it usually means transitioning the client, your customer, to a competitor. Return of customer data. This is just something one has to be, again, careful about to make sure that we are also complying with applicable law when we are returning customer data. Source code, technology escrows. It's surprising I see so many startup companies provide technology escrows as a matter of course, but it doesn't have to be that way. You don't have to provide a technology escrow, and the deal value, how long the deal is for, who the potential partner is for, all of those things matter, and just how what are the release clauses for the source code. These are all important considerations that we can assist you with. Business continuity, exit plans, change of control consent. Again, these are additional customer asks that need to be evaluated closely. Next. So just in concluding comments, and I recognize that I've kind of run through this presentation really quickly just to make sure we have some time for questions. Sort of recapping and concluding, as a provider, you really want to pay close attention to ensuring that your enterprise customer obtains adequate data permissions from their end user or consumer base so that you can conduct whatever processing functions you need to on that data set, as well as any functions, any use of blind data or aggregated data that you may undertake. So for example, if you are going to take non-personally identifiable information from that end user information that comes in, including, just how many times they visited a page, or what kind of purchasing habits they have, and you want to aggregate all of that to get a general demographic of, this is the age group which purchases these kind of products, or this is the age group which uses this particular functionality of the software most often. Whatever, all of those non-personal identifiable data sets that you generate from all this end user data that is getting processed, that you have sufficient rights to actually to collect and analyze that information for the aggregated anonymized functions as well. So you need adequate data permissions for that. I find customers agree to that quite often. Sometimes they push back, and sometimes they need to revise their privacy policies to take that into account. But that is something, if you need that data permission, then we need to put it on the table for discussion with the customer. Then, as a provider, you should pay close attention to ensuring that if you're going to use any anonymized data, that you properly de-identify and anonymize that data so that it's not reconstituted into personally identifiable data. Big data technologies usually are essentially providing a platform for use of their technologies to a large customer base. So keep in mind, try to use a uniform security standard and providing uniform service levels and remedies. Assessing risk, developing a playbook for risk allocation provisions, your lawyers can assist you with that. Obtain adequate insurance, and finally, watch for new Federal Trade Commission guidelines and privacy legislation to ensure that you are on track and complying with all laws, data-related laws. So with that, the last slide is just a little bit about myself and the firm, but I think we can go to questions.
Thank you, Satya. So one scenario that comes up a lot, it seems, is that we have a company here based in Silicon Valley, and they almost immediately go international, and one of the first things they'll do is set up a subsidiary in a foreign country, a base company someplace, Europe, for example, where they're gathering lots of data which ends up being stored back here in the U.S. Are there any particular problems or concerns with a company that does that?
Yeah, I think the biggest concern is if you're collecting data from EU-based end users, you have to comply with EU data privacy laws, or you have to sign up, and you have to sign up, it's a good idea to sign up with the US-EU safety harbor provisions, privacy-related safety harbor provisions. The first compliance-related issue is you need to inform the end users through your privacy policy or your customer's privacy policy that the EU end users' data is going to be transported out and transferred out of the EU to servers based outside the EU, and where those servers are. So almost always we include a statement in the privacy policy saying that that data may be transferred to the US. And then other compliance-related requirements is, if there's actually a data security-related breach, then you have notification-related compliance, which is very different in the EU than from the US. So that's something to keep in mind if there is an issue. But also, keep in mind EU data privacy and security laws are much more stringent than the US. And the only, the best way if you are a US company to work and make sure you are, can get the benefit of the security measures you're using in the US is to essentially do an audit of yourself and complete the requirements under the EU and US data privacy-related safety harbor, where you submit a form essentially describing your security measures, and that data, the safety harbor allows you to rely on US security measures in place of essentially the EU more stringent data security measures. It's a simple process, signing up and providing that form, but it's something that a lot of U.S. companies overlook, and then they find themselves, squarely in the middle of EU data privacy legislation.
Okay. Going back to one of your slides, you had mentioned a consequential damages limitation, and I think it might be worth pausing on that for a minute because I think I heard you say that you don't always get that, and there are a lot of contracts out there that may not have any limitation on the provider's liability for any consequential damages that might result from a breach of the agreement, including maybe an inadvertent disclosure of some information. Could we just pause on that for a minute? Just how bad could that be for a company? How big could those consequential damages be, and how important is it to limit liability, especially indemnification type liability?
Oh, consequential damages can go into several $million. I mean, it could be $20 million. It can be a really large number. I haven't pulled out any case law of late, but you're signing up to the lost profits of your customer, which could include essentially all the contracts that they lose with their downstream customers, all the end user traffic that moves away from their site, and it's all calculated then by various litigation formulas to arrive at a number which can be really significantly large. I mean, you cap your liability to a few $1 million. Now, if it's uncapped, your consequentials can result in potentially a very large number.
If it's something very serious, it could be the failure of the business, I suppose, if it's a very serious.
Absolutely. Absolutely.
Okay. And is the cap usually, is it sometimes some sort of maybe metric or multiple of the contract value or something like that?
The cap can be, it can be any formula. It could be just a fixed number. You could say $100,000, $50,000. It could be just the commissions or the fees paid during a 6-month period, 12-month period. It could be a multiple of that. It's something, there's no, I wouldn't say that there's a particular standard. That number just varies from transaction to transaction, even for the same client, for the same type of business. It depends on the bargaining strength of the parties. And to a great deal, it's really about if something, if I as a provider breached the obligations under this agreement, what is the dollar number I'm willing to accept given the transaction value I'm getting? And that, if you're doing business with any regular customer versus a strategic customer, can be very different. Typically, I would put in the hosting and the software as a service or platform as a service business, it's typically 12-month fees paid, and it's usually limited to 12 months of the subscription fee paid, as opposed to 12 months of all fees paid, because there can be a big implementation fee component. But we limit it typically to the subscription fee paid. But again, that number, it can be 2x or 3x if you're dealing with a strategic customer and they know that they've got the bargaining strength.
Okay. We have one really practical question that comes in. There's, I'm just going through listening to your presentation. I think it's a little overwhelming to see the extent of the regulatory environment and all the different rules that apply, some of which are really counterintuitive. And somebody asked, is there a way of estimating and maybe managing the costs right from the outset? Any practical advice on somebody who wants to get into a business that involves big data?
The biggest cost is around data security related breaches. And for that, my advice is, contractually follow a uniform practice of these are the data security measures we take, make them robust security measures, but then say, this is the universe of my security measures. This is what I take. You as a customer look at this today and you agree that these security measures are industry standards, at least at the date of signing of this agreement. So, you can, and you won't materially reduce that standard, but at the same time, we're not arbitrarily agreeing to to an industry standard that we have not defined. The additional thing is, again, all of those caps around the liability. That's really the key. If you are going to provide an indemnification, list out what are the kind of expenses you're going to cover the customer for. Notification-related costs, help desk-related costs. Are those the costs you're going to cover them for? Don't just agree to, we will cover you for any and all out-of-pocket expenses incurred by the customer. That could be a huge number. Out-of-pocket expenses could include, incidental costs of, engaging additional lawyers, additional investigation firms, forensics, all of that. So again, we need to understand what those expenses and costs are, make sure that this is within what is acceptable in the industry as a cost that a provider would undertake in such a situation, and limit it to that, and put an end number to it. My data breach cap number, so to say, is anywhere in the range of 3 to 7 million. Okay.
All right, we've got a few other questions that are very specific, and we'll follow up directly with you folks on that offline. With that, I would like to remind everybody that this webinar has been recorded. You'll find it on the RoyceUniversity.com website, as well as the Royce Law iTunes site, and Royce Law YouTube site, as well as on iTunes, available as a podcast download. Coming up, our next webinar is going to be on Tuesday, September 3rd at 10 o'clock. The title is Entrepreneurship is Risky Business, How to Avoid Potential Pitfalls. It'll be primarily concerned around HR and employment type liabilities. In September, we've also got presentations on alternative dispute resolution, arbitration mediation, a look at the current merger and acquisition environment, and a technical presentation on the new area, or not so new, but the area of food technology companies. And with that, I'm going to close the webinar. Thank you for attending.